views don't think there are any consequences for that. It's not something that campaign finance law should reach, so I'm arguing that campaign limits shouldn't argue to bequests. If you want to leave it all to some party, you should do that. I have a case in Michigan now I'm pursuing. This has been successful already to some large degree. I represent a local brewer whose beer was banned because the state of Michigan's Liquor Control Commission didn't like the label on the beer, and they thought it was offensive and immoral and bad for people to look at. And we explained that there's actually a First Amendment in this country, and they don't get to ban the beer because they don't like the label. They saw the light, they rescinded the ban, but we still have an action for damages that's open, so that's something. So yeah, I do other things as well. And,
very good.
You know.
Volkov wrote a law review describing a method of scrutiny to be used regarding gun laws. Can you...
Volk, yeah, Eugene Volk.
That's a show that I watch. Vala.
Eugene Volk, yeah.
Vala wrote a law review describing a method of scrutiny to be used regarding gun laws. Could you explain it? Does it work?
Yeah, well, Eugene Volk, obviously a brilliant professor at UCLA, writes a lot about Second Amendment issues, has written a lot in the field, and he has one article I think that's being referred to. I know the article. I agree with most of it, not all of it, but most of it, and I think all of it is useful and good reading. Again, courts, when they get constitutional cases, have been programmed over the years to look for these so-called standards of review. They really want to see whether or not a regulation of a constitutional right meets some level of scrutiny. They always have a test for weighing the individual interest in the right against the governmental interest in the regulation. And the tests are believed to be outcome determinative. That is, once you agree what kind of a test you're going to get, the result will often flow from that. So there's a lot of fight about which test do you apply. If you apply a really tough test, the outcome of that's going to be a good one for the plaintiff, for the individual. If you apply a very deferential test, then the government's usually going to win. Now, it's not a perfect result all the time. The government does sometimes win strict scrutiny cases, the toughest standard. Individuals do occasionally win, very rarely, the low levels of review, rational basis. But for the most part, the tests are important. So there's a battle to apply the toughest test possible for the Second Amendment, or the other side, of course, wants the weakest test possible, because that will determine those cases to which the tests are applicable. And the first thing that I would say is, from our perspective, we want to have as little as possible be decided under such a mechanism. If you can answer the question according to text, history, and tradition, then that's the way you should answer the question. If the Constitution says you're entitled to do something, that's it, okay? You don't then say, well, on the other hand, some professor doesn't like it. You only do that in those cases where the history doesn't actually command a result, or it's unclear how the framers would have looked at it, and at the same time, of course, it's very obvious that there's a Second Amendment right implicated. Now, what the courts are doing is something very interesting. The trend now is that the courts say, Second Amendment, okay, you know what? Rather than reinvent the wheel, we're going to just do what's been done for the First Amendment. And we're going to say that there isn't a one-size-fits-all standard. The standard of review is going to be different depending upon the nature of the case. And so if you have a case where it's a core aspect of the right that's being claimed by law-abiding, responsible people, we're going to apply a really tough test. The government's going to have a hard time. If, however, you have peripheral claims, something that's thought of as being a little wacky perhaps, or more easy to say that people making the claim are not law-abiding, not responsible, then we're going to apply a lower level of review, although even there, the lowest level of review they'll use is something called intermediate scrutiny. They won't go all the way down to the bottom. Mostly we've seen so far intermediate scrutiny because the courts, while they've announced this, they haven't had too many cases where they've actually had to apply the the test in a circumstance where it would be a core right being asserted by law-abiding, responsible people. The one area where they sort of did was Ezel. The court, in that case, my gun range case in Chicago, said, look, we've previously used intermediate scrutiny for dealing with criminals, people who are domestic violence misdemeanors. But these are law-abiding people. Using a gun range is a core aspect of the right, and we're going to require something much higher than that, if not quite strict scrutiny, definitely something tougher, and Chicago should have gotten the message from that. I suspect they will in the next round. So again, it depends on the facts, but courts, so long as they keep saying they're going to follow the First Amendment, that's a good thing for us. You know, the First Amendment, not perfectly interpreted, but it's a fairly robust right. I mean, courts do really enforce it more than once in a while. And if we can get that kind of treatment for the Second Amendment, we're going to be in good shape.
This person writes, they have a court date scheduled to argue a denial of concealed carry permit. They're asking for your advice about how they could go about arguing the case. And a little information, I am an officer of the state, but I don't have the same rules as correction officers, but I do watch the criminally insane. This is person's job is, I guess, working with criminally insane.
Well, I guess they're in politics, or well, I can't really give legal advice to anonymous people who submit a card telling you how to argue your case. So I can say good luck. I mean, I'm not sure how. I mean, I can't give legal advice under that circumstance.
It's tough to answer And the last official question
okay.
I have, and then it'll be up to you if you'd like to take additional questions from the audience. Do you ever pull other attorneys for advice? And if so, who and for what?
Oh yeah, sure. I mean, look, I don't do this all by myself. You know, I always frequently work with other people. Heller was a team effort. McDonald was a team effort. Most of the cases I do, I work with other lawyers, sometimes informally, sometimes formally. Part of it is speaking to, well, there are two kinds of people that I've worked with in these cases. What I would call people who are subject matter experts, people who are perhaps attorneys but more likely scholars. You know, if somebody has spent a lifetime reading musty old documents in a courthouse basement somewhere and otherwise gathered, you know, original information, that's a very important person to consult with. You know, and I definitely rely upon people who've done that, whether they have a law license or not, and upon the literature that's been developed by those individuals. And then, of course, there are people who whether or not they have that kind of experience, are also good lawyers and know something about the business of law. And sometimes people who've got both kinds of experience to various degrees. Some of these people, their names appear on briefs along with me, or they go to court with me, and sometimes they're not. They don't, but at the very least, I cite their work. No, this is not something that I can do all by myself, or that I've invented entirely. I would like to say, though, that, and this is, I only hesitate to give you names because I don't want to leave anyone out. So with the understanding that some people might be left out, not intentionally, I can tell you that, you know, David Jensen, who's spoken to you earlier, somebody I work with, David Siegel in Chicago, David Hardy. Not everyone's called David, by the way. David Kopel. You know, but you know, those are people that I've worked with. Another David who's been very good, David Young, written a number of books about the Second Amendment. Not a lawyer, but he's better than that. His books are exceptional, and I think they have a lot of good original research in them. I don't want to leave people out, but you know, if you're out there watching and listening, and I've left your name out, then send me an angry email later, and I'm sorry. But this does raise another issue, which is, I think, probably the biggest danger we have in this field, which is while there are people out there, not just me, other people who are very good at what they do. Don Kilmer, excellent lawyer in California. Sorry, I didn't want to leave him out. So, okay, Don, don't send me an email. While there are people out there who are very good and are doing good work, there are also people who should probably find other hobbies. And, you know, this is the problem we have. There is nothing that prevents an angry person who has gotten riled up reading the internet or something late at night from walking into a court with $350 and filing a lawsuit. That is not a good strategy for success. You've all heard the adage about if you are your own client, you have a, you know what, for a client. And, you know, pro se cases are not the way to do it. There are definitely arrogant lawyers out there. Maybe I'm one of them, I don't know. But there's nobody more arrogant than someone who is delusional enough to think that they can do this all by themselves, representing themselves oftentimes without the benefit of any sort of legal experience or background or training. But those people do have their cases heard, of course, and they wind up coming up with decisions that we all have to deal with. Not every case that deserves to win should be filed. There are strategic considerations to be made in all these cases. Not everybody makes the best plaintiff. Not everybody is qualified to represent themselves, but this is a serious issue for us. We do have people out there doing this who really are not remotely qualified to do it, and they do cause damage. That's different than other lawyers with whom we may have a disagreement, you know. Yes, lawyers disagree with each other, that's fine, that's normal. If another professional differs in their opinion from mine, that's fine. I respect that. Not everyone's going to agree on everything. It's very different than some lunatic out there going and making a kamikaze type effort. We have that in this country, and that's a problem. Nothing I could do about that, though. Nothing.
I have another question, though,
Sure.
before we proceed. I just want to please ask everybody, when we're finished, don't run right out. I just have a few words that I need to say before you leave, if you don't mind. Alan, there's one last question here. It says, once my application, this is an interesting question because I think a lot of people have this question. Once my application to carry has been denied, should I go to court? Would it help the cause?
Again.
Would it help future cases?
Probably not. You know, this is the thing. You know, right now, let's talk about New Jersey, okay? There is a case now from New Jersey in the Third Circuit, the Pizatowski case, okay? That case is going to be decided one way or another, and whether it goes to the Supreme Court, some other case on the topic probably will. But in New Jersey, if you were to file a case now in district court, if you had the best possible case, and you're going to go to court and file it, chances are you're going to run into a very hostile district judge who is going to make a bad decision before the Third Circuit's going to have anything to say about the case that's already up there. That is, you're mathematically eliminated from being the decisive case because you're behind on the calendar. Okay, there's this other case ahead of yours, which will become the controlling case. So why go to court, file a case, probably not get necessarily the greatest result that will then be cited at us on the appeal. And we are seeing that in some places, and there are cases out there that are, you know, what I would call late filed. And I would say to those people, and I've said to some of these people, look, I'm sympathetic, you're correct, you're a good person, you don't deserve to have this happen to you. But there are, you know, a half a dozen cases already in the Court of Appeals. Many have been fully briefed. Some have been argued. You know, why are you going to bring another one right now in the same jurisdiction? It doesn't make sense. And it's not a good use of our resources, so I'm not going to be able to devote the very limited resources we've got to taking on the umpteenth case on the same issue from the same place. Again, one of the things that we have to think about. To some extent, you know, to a complete extent, we have to put our best foot forward. And to some extent, we are also in a race against the various clocks that are out there. The courts may or may not be improving for us. We have crazy people out there filing things, we definitely want to make sure that they aren't the ones that get adjudicated first. But we don't want to, just do things because we feel good about doing them. Again, remember, it's not about whether you're right or wrong. It's about what can you do to win, and that requires sometimes more caution. Thanks.
Thank you, Ron. That's very important for us
Thanks.
to know because it's, there's, I know a number of people have asked that question to me. Before we go any further, you've been up there for quite a long time. You've
Sure.
answered a lot of questions. And I don't want to keep you up there any longer than need be, but I just give you the option if you wanted to take any further questions from the audience.
I'll take one more question. That one right there. You're fastest hand up in the.
It's probably a stupid one, but I might as well burn it.
No.
After Heller McDonald law gets decided, what happens to the poor bastard who got arrested for it the week before, where now all of a sudden it's not illegal, the thing that he, or she got in trouble for? What happens to all those people that it just turns out were not criminals?
Okay.
Charges get dropped, they get let out, they get their fines back. What's the story?
Well, it's a complicated story. If the case is still open, if they were just arrested and they're waiting trial, then the decision applies. When the Supreme Court announces a legal principle, that is the principle that is effective for all future cases, but also for all cases that are currently existing. If somebody was convicted, 5 years ago, 10 years ago of something that gets struck down, then they have other options in their jurisdiction. The courts there might be able to entertain what's called the writ for quorum nobis. You can go in and say, look, this was an unconstitutional principle, or if that's not available to you, perhaps you might need habeas relief if you're still in jail. You might have an expungement available to you. There are different options available. I'm not qualified to give that level of advice. This is a general question, but people who have been convicted of something that's been since struck down should consult with an attorney to see if they have any options. They might have options available to them. For people that are still awaiting a resolution, that's good. That's good law for them right now. So.
It only even came because, think about prohibition and all the habits that were taken off the barrel, and then they finally,
Yeah.
get rid of prohibition. Well, you just destroyed all these people's things, and
You can't make up for everything. It's true. I mean, some things are, you're never going to, it's sad. It's true. Yeah. Although I think all the prohibition victims are probably, not with us.
Okay.
Thanks.
On behalf of the board.
Thanks.